Meeting to order, Tuesday, January 24th, 2023 at 6:30 p.m. City Council Chambers. We'll start with pledge of allegiance. Pledge of allegiance. Flag of the United States of America. Clerk, please do the roll call.
Alderman Johnson.
Present.
Alderman Fairwell.
Here.
Alderman Rita. Alderman Montoya. Alderman McGee. Alderman Carr. Here. Alderman Roll.
Here.
This here, Your Honor.
Thank you. Your public comments? Public comments? Any public comments? Moving on. So the special agenda only has one item. Alderman, has everyone had the opportunity to review the record of proceedings from the hearing relating to Ravens Place LLC that happened on January 6, 2023? My findings, decisions, and orders entered after the hearing, the city code relating to business licensure revocation, appeal procedures, and licensee appeal statement, all of which were distributed to you on January 19, 2023. Everybody was in receipt of that? At this time, is there anything additional Mr. Thomas or Ms. Ryan, Ravens Place attorney, would like to say to the city council in regard to this appeal? If so, I ask that you keep your argument to 10 minutes, given the lengthy appeal statement already provided to and reviewed by the alderman. If needed, you can also have 5 minutes for rebuttal argument.
The licensee retain also like statements.
Okay.
And then I'll walk about.
Good evening, ladies and gentlemen. As you all know, my name is Ray Thomas, Ravens Place LLC. Ravens Place has been operating in Blue Island since 2011. Since that time, we've had multiple administrations leading the way here in Blue Island, and we've enjoyed a good relationship with them. There has been many problems. There have been no problems or issues with the business or complaints from the community up until COVID 2020. In 2013, we decided not to be a transient business here in Blue Island and purchased our first building. By 2019, we had expanded our business by purchasing the remainder of the block. Our property stretches from New Street to Vermont on Western Avenue in Uptown District of the city. Ravens Place LLC as an organization and myself personally are questioning how our relationship with this city went south. How did we get here? We have supported the community and current administration with fundraisers and donations to maintain our friendly, open relationship. In May of 2021, when this administration took office, there was an initial agreement that was signed due to an incident that occurred. I told the village administrator, Mayor Bellato, and Chief Barr how it was unfair and restricted my business in a negative way. A year and 6 months went by, no incidents from my business here in Blue Island. On September the 17th, 2022, there was an incident that occurred in the municipal lot after we closed. The administration wanted to place additional restrictions on Ravens Place that would cripple our business. During this same year, there were multiple shootings inside of venues in Blue Island where people were injured and killed. Yet our agreement contained much harsher and restrictive penalties than other agreements imposed on those establishments. We questioned the goodwill of the relationship and decided it was not in the best interest of Ravens Place LLC to sign another agreement with the current administration. The liquor commissioner revoked our liquor license for an incident that did not happen on our property and was not provoked by anything that happened inside of our venue. As a matter of fact, the vault was closed and not open for business that evening. This incident occurred on municipal property, and our security detail tried to defend the patrons that were on the sidewalk parallel to Ravens Place as gunfire was being fired back at Ravens Place. This incident was very unfortunate, and I wish it had never happened. We as an organization decided to appeal the local liquor commissioner's findings and allow the state liquor commission to decide the facts of the case, and we were allowed to reopen both businesses. Fast forward to Friday, December 30th, 2022 at 5:54 p.m., we received a letter from the assistant city administrator that states our liquor license application was being rejected due to us not providing documents and the current information on our liquor license. The letter stated that we had to close the business at 12:01 a.m. on January 1st, 2023, which we complied. To our surprise, there was an incident that occurred again on the municipal lot at 12:02 on January 1st. There was a person that allegedly left our business and fired a weapon in the air on municipal parking lot behind another bar. No one came to our facility to investigate, retrieve video, surveillance footage, ID scanner data. We found out on January 3rd that our business license was potentially being revoked and our liquor license was being revoked again. The complete lack of transparency, unwillingness to communicate, and tactics used to close the business again has shown our organization that the current city administration does not value the relationship we have built over the past decade. We ask the city council to reverse the revocation of our business license and allow the facts and merits of the current appeal at the Illinois Liquor Commission to be heard and decided in its entirety prior to shutting down our business.
Brian?
Thank you. Good evening, members of the council. My name is Heather Ryan. I am the attorney for licensee Ravens Place Inc. And we are here obviously because this is a review of the mayor's decision. We did have a hearing on January 6th of 2023, and evidence was presented in both oral and documentary evidence. There was Detective Bailey testified, Chief Barr testified, Deputy City Administrator Mark Tosca testified, and so did Ray Thomas. At the close of all the evidence, the mayor did issue a decision revoking the business and liquor licenses of Ravens Place Inc.'s businesses, being the Vault and Ravens Place. We are here tonight to appeal that decision to the city council because you are the appellate body. You are the checks and balances of government for overreaching by the mayor in this circumstance. It is your duty to stop the government overreaching of the mayor and his decision in this instance. The law is clear that you must overturn the mayor's decision of revocation when the facts do not support the findings. If you find that the evidence does not support the findings, then you order a revocation that is against the manifest weight of the evidence, which is exactly what happened and cannot be upheld. Why should it be reversed? There are three main categories why it should be reversed. And the law requires, number one, that the findings support, or the evidence support the findings. In this circumstance, the findings were against the manifest weight of the evidence. Secondly, it should be reversed because the law requires the order or the mayor to consider mitigating evidence, and the mitigating evidence does not substantiate a revocation in this instance. And finally, the city denied licensee the right to due process in various ways, and the law requires due process in this instance. How did the evidence not support the order? Much of what was presented was hearsay evidence, and the law requires that hearsay evidence be excluded if it is not warranted or if it's not relied upon in the regular course of business. Much of the evidence that was presented was evidence that was based on hearsay testimony by an arrestee from that evening that shot her weapon into the air in a municipal parking lot. Much of the evidence was given by the arrestee, and much of the evidence was given based on her ideas of ages of people and so forth. And again, that's unreliable hearsay evidence that cannot be considered an issue in a finding, especially a finding that warrants revocation. Specifically, the city failed to prove that Ravens Place runs a commercial establishment located within the city and impacts the physical and economic well-being of the city and necessitates services from the city in the form of fire, health, police, and other services. Again, the evidence the city presented was that an individual shot her firearm into the air at 12:02 a.m. in the municipal parking lot located behind Double Place Saloon. There was no evidence presented that any criminal act or gun violence ever occurred on or within the licensee's premises or parking lot. There is zero evidence the licensee created or failed to abate any conduct that impacted the physical and economic well-being of the city. There was never any evidence the licensee required or requested services of the city in the form of fire, health, or police, or any other services for that matter. Just because the police responded to an individual stupidly discharging her firearm 2 minutes after midnight of the new year while parked in the municipal parking lot must not be attributed to the licensee. There was no investigation as to any of the establishments the arrestee patronized that evening, and the city relies on a police interrogation, again, the hearsay video, where the arrestee purports to have been at the vault that evening. However, there is absolutely no independent corroboration that that individual was in the vault that evening. Certainly there's surveillance video, there's ID scanners, things that could have been pulled by police to prove that there's nothing independently corroborating the fact that that individual was at the vault. Even if the members of the council choose to believe the arrestee was solely a patron of the vault, the licensee cannot be required to follow every patron to their vehicle wherever is parked within city limits to ensure that no firearms are contained within their vehicles. And as previously noted, that individual did have a valid CCL employee card and was exercising her constitutional rights, albeit stupidly discharging it. That again is not something the fault can be placed on the licensee. That was in a municipal parking lot, and nothing unlawful occurred at either the vault or Ravens Place, or the property immediately adjacent to that, or the parking lot that it owns. The city is inappropriately shifting the burden of policing on the licensee. Further, the city failed to prove the conduct of the business of the licensee constitutes a nuisance as defined in Chapter 95 of the City Code and Chapter 110 of the City Code. There's no evidence that the licensee's establishment was conducted or operated as nuisance property, and the city wants to unfairly place blame on the licensee for unfortunate events that occurred on a municipal property. They have repeatedly showed how the licensee has conducted or operated its business in such a manner as to be dangerous to the life that is detrimental to the health of the public. In fact, quite the opposite. There's been much mitigation on the part of Ravens Place LLC, and that was failed to be considered. The licensee on the evening of December 31st, 2022, employed no less than 15 security guards for the roughly 600 people that attended their establishments throughout the evening. That the reason that there were security guards there and that number proves and shows why there were no issues on either of the licensee's property, because the licensee had strictly enforced security policies as a matter of protocol. The mayor failed to consider that the licensee was in full compliance with the May 18, 2021 agreement on the evening of December 31st, 2022, and the early morning hours of January 1st, 2023. There's no evidence to the contrary that the licensee was in violation of any federal, state, or local laws that evening. There is no evidence that evening that the licensee was in violation of the May 18, 2021 agreement. The only evidence, again, that the city is relying on from that hearing was hearsay evidence, which should not be considered from an arrestee who claims that she came from the vault and was with another individual at the under the age of 24. I'm sorry, under the age of 25. That individual allegedly being 21. Again, that was never independently corroborated. The individual that apparently was 21 was never asked for ID. There was no evidence or testimony with regard to that at the hearing. And the mitigation and adherence to the May 18, 2020 agreement demonstrates the licensee is committed to working with the community to ensure the licensee's establishments remain safe. In light of the licensee's actions, the revocation order is overly harsh and must be overturned because the licensee has actively responded to the concerns of the city. The city's overzealous prosecution of this matter is nonsensical and raises serious questions about city's motivation for overreach. There's no dispute that the patrons of Ravens Place and the vault are predominantly Black citizens. The city appears to have selectively prosecuted licensee and its establishments and repeatedly fails to hold other establishments accountable, even though those establishments are adjacent and located on the same property as that municipal parking lot. Further, the licensee takes the position that it's constitutional rights due process were violated because there was not a fair and impartial hearing that was given. And that was evident in the transcripts that are provided to the city council. The city council should reverse the mayor's revocation order on independent ground that the city denied Ravens Place the right to a fair hearing and an impartial hearing officer. A fair hearing requires a hearing officer to be fair and impartial, without bias or conflict of interest. And the mayor repeatedly blurred out statements on the record during the hearing without the city having opportunity to examine. This is a basic administrative rule, code section 1040 under rules of evidence, that in contested cases subject to evidentiary requirements of that section, a party may cross-examine in order to have a fair, full disclosure of the facts. And the licensee did not get that opportunity when the mayor injects himself as a witness to provide testimony on the record. Asking the mayor to judge credibility of the city's allegations, the city's employees, and the city's evidence, and to make a ruling independent of the desires of the cities, belies the basic principles of the Constitution and the right to due process. The Illinois State Bar Association, in its opinion, cited by the Illinois Supreme Court to reinforce the classical principles of jurisprudence, is that no man who has a personal interest in the subject matter of a decision may sit in judgment of the case. And that's exactly what happened here. And this is why we're appealing to the members of the City Council to fairly and impartially make a decision with regard to the facts in this case. We also ask you to take into consideration the discipline and unfair treatment or unequal treatment of the licensee in comparison to other incidents that have happened within the city. Specifically, Harry's Lawn Bar and Borough Pool, where their discipline was quite different than the discipline that was afforded the licensee. The licensee, however, has adhered to security plans. He has installed flat cameras, he employs security guards, he employs and uses ID scanners. And his security guards are actually armed and do patrol the licensee's premises and the adjacent property to make sure it's safe. And it's interesting to note that there's nothing ever happening on the licensing property or within the confines of either the vault or Ravens Place. It's a safe environment because of the strict standards and safety protocol that Mr. Thomas adheres to. So for the reasons stated, we ask that the decision of the mayor be overturned. And again, specifically because the evidence did not match the findings of fact. The order of revocation failed to consider the mitigating evidence, which overwhelmingly supports overturning that decision, and that the city denied a fair and impartial hearing on the right to due process to licensee. We take all that into consideration, and on your deliberations, just ask you to take an actual look at the evidence that was presented on the hearing on January 6th, because it falls very short of the findings that were actually made by the mayor in issuing the order of revocation.
Alderman, do you have any questions for Ravens Place, their attorney? Ms. Blake, is there anything from the city prosecution would like to say to the city council?
Good evening, Alderman, Alderwoman. The law cited by Ms. Ryan is not entirely correct. The law that you are being asked to review and enforce is based on the Blue Island City Code. That's chapter 110 of the city code. And just one instance of Ms. Ryan being incorrect is regarding hearsay evidence. Pursuant to the city's code, which has never been held invalid by any Supreme Court, and pursuant to the procedures in our code, which are very similar to other municipal procedures throughout the Chicagoland area and the suburbs. Hearsay evidence is admissible in administrative hearings. If you look at our chapter 110 of the code, it states those specifically. So I'm just asking that you don't take everything Mrs. Ryan said regarding the law as true. I'd ask that you look at the city code if you have any questions regarding the law, and that's chapter 110. Pursuant to section 110.5 of the city code, the order of the mayor in relation to Ravens Place LLC's business license shall not be reversed by the city council unless it was demonstrated by clear and convincing evidence that the previous ruling by the mayor was invalid because it was made on unreasonable grounds or was unsupported by the evidence. The lengthy record of proceedings that was provided to you by the city last week, which I know you reviewed prior to the appeal hearing today, it speaks for itself. And there's nothing stated in Ravens Place LLC's appeal statement, nor stated today by Ms. Ryan or Mr. Thomas, that demonstrates that the mayor's decision to revoke the business licensure was unreasonable or unsupported by the evidence. There was plenty of evidence provided during that lengthy hearing for the mayor to have ruled in the manner in which he did, which was to revoke this business license. There has been no selective prosecution, no discrimination, and Ravens Place LLC was given a fair hearing and awarded all the due process that was required to them of the city code. The mayor made this decision to revoke the business licensure as he stated in his findings and decision, which were also reviewed by you. He found, based on the evidence that was presented during the hearing, that the business is a nuisance to the city. There was also evidence that the business is a clear and present danger to the public's safety and general welfare in the city of Blue Island. There was also evidence that the business had violated its safety plan on more than one occasion. And based on that evidence, the business repeatedly failed to comply with the city ordinances. All of these reasons and every additional reason stated in the mayor's findings and decisions in final order was supported by the evidence and does provide a reasonable grounds for the mayor to have revoked Ravens Place LLC's business license. Therefore, the city council should deny Ravens Place LLC's appeal and affirm the mayor's decision to revoke the business licensure to both Ravens Place and the malls. Thank you.
Ms. Ryan, rebuttal.
Just briefly, so I know you all have the appeal that I cited and specifically addressing the hearsay issue and the case law that is in play with regard to the inadmissible hearsay is Cochran's of Champaign Inc. versus State Liquor Control Commission. These are administrative hearings where the ages of the people were under 21, which is not what we have here. And that case was overturned because it was overturned at the local level because the local level allowed impermissible hearsay. And I implore you to look at that case, and the site is there. And I've also attached it as an exhibit so you can see how my statements are accurate and well settled law in the state of Illinois. It's very easy for the city to come up here and say there's numerous violations. He hasn't complied with the agreements, but they never say how. They never say how or why or give any details. They just make these blanket statements that he's a nuisance. And what it always comes back to is the gunfire that's occurred, and the gunfire has never occurred on Mr. Thomas's property. It's never occurred in any of the establishments. That is never occurred anywhere that is licensed by Ravens Place LLC. It happens on municipal lots. It's unfortunate. Mr. Thomas has had absolutely no problems until COVID year 2020, zero. There's never been any issues. And as you see in the news, the climate of gun violence since 2020 has arisen everywhere. And unfortunately, it's arisen in your city too. But that's a police issue. And we cannot require Mr. Thomas to follow each and every alleged patron of his establishment to the vehicles to make sure that somebody doesn't make a stupid mistake. How far does the licensee have to follow the patrons out of the city to not be blamed for gunfire incidents or any other unlawful incidents? Does he have to follow them up to the gas station to make sure nothing happens? Because the way that the city is blaming Mr. Thomas and Ravens Place LLC seems to be that way. If you happen to be a black individual with a gun that is discharged within the city confines, and they happen to mention at any point in time they were at Ravens Place or the vault, the licensee is going to be blamed for that. And that's not fair. He's required to keep his premises safe. He's required to keep his parking lot safe, and he does that. Because you will never find any incidents where there's been an incident of gunfire on or within his property. Unlike other businesses within Blue Island. We ask that you consider that. The order of application is too harsh. You need to consider the mitigated circumstances and all of the safety protocols that you put in place when you make your deliberations and decide on whether or not to overturn this.
Motion to executive session. Alderman Roll, second by Alderman Fairwell, all in favor, say aye. Aye. Any opposed? Reconvene the session. Motion to read the regular session. Alderman Olson, Alderman Fairwell, all in favor, say aye. Aye. Any opposed? So as the council has two decisions to make, one decision to make, either it's an overturn of the mayor's decision, regarding the business licensure, or a motion to deny the appeal. Raven Place LLC, and affirm the mayor's decision to revoke Raven's Place LLC business licensure. Is there a motion on the floor? Motion by Alderman Fairwell, is there a second? Alderman Roll. What's Alderman Fairwell, what was the exact motion you're making?
To deny the revocation,
Making a motion to deny the appeal,
or the appeal, pardon.
to affirm the mayor's decision to revoke business licensure.
That's correct.
Is there a second? Alderman Roll on the question. Clerk, please do the roll call.
Alderman Johnson.
Aye.
Alderman Fairwell.
Aye.
Alderman Rita, oh, sorry. Alderman Montoya.
Aye.
Alderman McGee.
Aye.
Alderman Carr.
Aye.
Alderman Roll.
Aye.
6 ayes, Your Honor.
Carries. I'll finish. Is there any Alderman comments or questions or anything before we close out? I need a motion to adjourn the special meeting. Alderman Fairwell, second by Alderman Roll, all in favor, say aye. Aye. Any opposed? Do a short recess between this and the regular meeting.